but still that cash flow has to generate that yield. And it has to be entrepreneurial. It has to be probably a startup venture or a venture that has been flagging, has had difficulties, and is being reborn. And I'll give you an example or two of how that would work. Now, let me talk about a couple of entities I'm working on in creating L3Cs to flesh this out for you. One is I'm working with a client that is going to be offering a web-based financial literacy program for teenagers. And they happen to be based in California. And we're working with a foundation to fund that. And again, it's an educational purpose. And it's a brand new business, a startup, with some very competent people behind it. But they're doing it they need to do it in a leveraged way. There isn't the capital to support a more traditional entry. Even if they were, it seems to me this is kind of an attractive opportunity for foundations and others. So that's one. Second I'm working on, more local, is to provide below interest loans to the L3C's customers to fund LED lighting, conversion to LED lighting, which has a very long payback period, but ultimately is very attractive both in terms of the environment and in terms of the value proposition, and also from a marketing perspective for the customers. But they couldn't make the economics work if the customer would have financed the conversion. The payback is just too long. Well, here we're able to provide below market interest financing this opportunity. A third venture in which I'm only peripherally involved, but I can tell you about it because I think it has very significant implications, is a newspaper. And there had been a presumption in the tax law that the newspaper business is a for-profit venture. It cannot have a 501c3 type purpose. However, all of that came before the newspaper industry started collapsing. So, what is the social purpose? The social purpose is, one, to maintain and create jobs. Two, to educate the electorate. Three, to serve as a vehicle for posting of public notices, which are required by many statutes in newspapers of general circulation. I see media, by the way, as a likely beneficiary of the L3C form, because as the media industry goes through its transformation, we may all benefit from the fact that there is a means of keeping media outlets alive and disseminating information from lots of different points of view. So I see that as something that may in fact be evidenced throughout the country. But I just made a note of a few other kinds of L3Cs that are likely to be taking shape in terms of purpose. And you'll see the breadth and diversity of the opportunity. One is affordable housing, community development, cultural organizations, historic preservation, charter schools, health clinics, child care centers. All of these could be 501c3 organizations, but also could be for-profit, social purpose businesses, and then lend themselves to it. Well, there is one other piece to this puzzle. And the piece to the puzzle is, how do we know that an entity, in fact, will receive money from a foundation that will later be respected by the Internal Revenue Service as a program-related investment? And there is legislation being introduced in Congress this year that will solve that problem. And it's essentially a presumptive registration opportunity for the L3C, which, and this is a very brief excerpt from the bill, which shifts the presumption that today requires the foundation to prove that its program-related investment qualifies, such that now the burden of proof is going to be on the Internal Revenue Service to say it doesn't qualify. This stands the tax law on its head, I think, in a very favorable way. It also will allow for short-form registrations by L3Cs with the Internal Revenue Service, and those registrations will result in an approval letter from the Internal Revenue Service upon which not only the L3C can rely, but all foundations in the country can rely. And if an L3C has now this seal of approval from the Internal Revenue Service, any foundation can, without risk or concern, make program-related investments to the L3C. There is a procedural implication to this that I want to point out to you. I had mentioned earlier that there, under today's law, is an opportunity for foundations to go out and get a private letter ruling from the Internal Revenue Service. The presumptive registration approach will not be handled by that unit of the Internal Revenue Service that handles private letter rulings. Those are very rigorous analyses done by attorneys who are going to be scrutinizing applications to the nth degree. That's not what this is going to be about. The way this will work instead is it will be to a unit of the Internal Revenue Service that reviews applications for determination of tax exemption, and their instructions will be to go over this very lightly. And the assumption will be, this is going to be okay. So you're not going to have tax attorneys second-guessing the L3C. I've been told as recently as today, the hope is that the application will be as short as one page. And the folks in the Internal Revenue Service will eyeball it, stamp it, send it back, and the L3C is home. So the L3C gets approval. With that approval, major foundations will be more comfortable in making program-related investments. Even without that approval, my expectation is that lots of foundations will rely upon the shift in presumption that the statute federally will provide. Now, I mentioned this as a state-by-state affair. Vermont was the first state in the country to adopt L3C legislation, and it was last year. I should point out both houses of the Vermont legislature passed the L3C legislation unanimously, and then a governor of the opposite party signed it. So this is deemed to be a universal good. Michigan, just on the 15th of this month, became the second state to adopt L3C legislation. I should tell you, this is a list of the states where legislation is in various stages, all of which are expected to be enacted this year. And we're going to have Jen Walling talk to us more about the Illinois status in a moment. But I want to mention to you, there is one other statute that was enacted in January, just this month, that's not on the list. But it's an interesting one for you to know about. The reason it's not on the list, it's not a state. It's an Indian tribe. It's the Sovereign Crow tribe. And what's interesting about that is, I can give you a little backstory, which I think you'll find fun. The Crow tribe has its own laws. And the tribe has now decided that it wants to engage in commerce with the 50 states. The Crow tribe consists, I think, of a grand total of 15,000 people. And they were told, you know, you have to have real laws the way everybody else recognizes them. First battle there was proposed that there be a foreclosure law. So, well, no, we cannot dispossess people of the tribe. So, well, without that, you're not going to get commercial lenders to come in if there's no remedy in the event of a default. So they eventually approved that, and now they've adopted the Uniform Commercial Code for commercial transactions otherwise. But they see the L3C as an economic development opportunity to bring in money, both foundation money and private sector money, into the tribe for business purposes. The business will then become successful. The foundation will then redeem its shares, get its cash back, get its